Thank you, Volker, for that presentation. I am going to share my slides. And thank you also for the invitation to participate in this Plamadiso talk. I will be, as you said, I will be presenting my recent working paper, which considers the interplay between the competitive dynamics of generative AI and the European tech regulation addressing market power, the Digital Markets Act, or as we call it, the DMA. I have divided the presentation into five sections to make it easier to follow. First, I will be addressing what the discussion is all about. Why should we bother at all about this intersection between the DMA and AI? Second, I will also address the risks generated by generative AI and try to translate them to the language of the DMA. And after that, I will set out the three courses of action that the enforcer, the European Commission, could trigger to address these risks via regulation, namely to analyze three different scenarios. First, whether the currently captured services may be impacted by the incorporation of generative AI functionalities. Second, whether the European Commission may designate new services to capture these legal challenges. And the last one, whether the DMA should be amended to incorporate generative AI as a service to be captured via the regulation. Given that the DMA is quite a new piece of regulation, I will briefly underscore a few points about its adoption and also about its institutional framework. First of all, what is the DMA? So the DMA does not directly pursue the protection of an undistorted functioning of competition. In fact, the underlying premise of the regulation is that some digital markets are already distorted, so that regulation is necessary to correct those distortions. The main objectives of the DMA are therefore to ensure contestable and fair markets for these digital services. Contestability aims to ensure that no barriers to entry and to expansion exist when competitors try to outsmart the incumbent big tech platforms in the market. And in turn, fairness intends to restore the imbalances in the rights and the obligations of competitors vis-a-vis those that gatekeepers possess due to their position. The funny thing, however, about the DMA is that the obligations that it imposes on the regulatory targets, the gatekeepers, to ensure contestable and fair markets come precisely from the antitrust framework. Basically, the remedies proposed by competition authorities are now enshrined as prescriptive and proscriptive obligations under Articles 5, 6, and 7 of the DMA. And in parallel, the DMA also addresses fragmentation in the internal market, meaning that the regulation is the only set of rules to address digital rulemaking at the EU level. The European Union realized that it could not have 27 different regulations impacting the biggest digital tech firms in the world, and that was precisely what some of the member states were doing at the time. Due to this reason, the DMA's enforcement is centralized, and the European Commission is the only one in charge to interpret and analyze compliance with the regulation. Moving along those lines, the DMA differs from antitrust to the extent that it is not a horizontal regulation. It does not apply to every single service in the economy or the services catered via digital firms. Instead, the DMA is an asymmetrical regulation, so that the regulatory targets or the gatekeepers will only remain captured by the DMA to the extent that the European Commission issues a designation decision regarding their gatekeeper status. For operating that particular designation, an undertaking must fulfill two requirements. The first one is that it must be a gatekeeper in the sense of the DMA, and the second, that it must cater for a core platform service or a CPS in the market. Regarding the first of the requirements, the European Commission must check whether the undertaking is an important gateway for business users to reach end users in the market. And second, and most importantly, I would say for the purpose of this discussion, is that the designation operates in relation to particular services. The DMA includes in its Article 2.2 a list of 10 core platform services, which are the ones displayed now on the slide, including, for instance, search engines, web browsers, or video sharing platform services. So that, and as you'll see from the slide, none of the CPS categories include anything related to generative AI or AI services in general. Stemming from this general framework, the European Commission has now designated 7 gatekeepers: Alphabet, Amazon, Apple, ByteDance, Meta, Microsoft, and Booking.com, for 24 core platform services. For instance, not all of Alphabet's services remain captured by the regulation. Only its Google Maps, Play, Shopping, Search, YouTube, Android, Chrome, and Ads services. What does that mean in practice? Well, it means that a whole range of substantive obligations apply to those CPSs that have been designated by the European Commission in the period of 6 months since the designation was operated. And those obligations specifically applying to the services are those that we can find in Articles 5, 6, and 7 of the DMA. Those mandates include transformations to the gatekeepers' business models in a number of ways. For instance, the gatekeeper cannot leverage personal data across its CPSs, or it cannot incur in self-preferencing when ranking results involving its own related services when they act in competition with other economic operators. Procedurally, the DMA also differs from antitrust in the sense that it operates a complete reversal of the burden of proof assigned to the undertakings, in the sense that it is not the European Commission which must demonstrate the existence of an infringement in the sanctioning proceedings, but instead the DMA compels the target, the gatekeeper, to submit each year a compliance report detailing all of the technical solutions that it has implemented to adapt to the obligations falling within the scope of Articles 5, 6, and 7. Against this background, one could dare to ask why generative AI was not included in the DMA when the EU legislator was finalizing the text for its adoption. Well, the answer is that it was technically impossible. The regulation was first proposed in December 2020 by the European Commission, and the European Parliament and the Council participated in trilogue negotiations up until March 2022, when the final text of the DMA was finalized for its adoption. In terms of the CPS list that we have seen before, the European Parliament managed to increase the 8 initial CPSs proposed by the European Commission in December 2020 to 2 more, including virtual assistants and cloud computing services. The text, however, at that point in time could not be changed further. After that, the DMA was also published in the Official Journal of the European Union, and it entered into force in November 2022. And it was precisely by November 2022 that the first chatbots were released by entrant OpenAI, followed by Google's Bard, now Gemini, and Meta's open source Llama. The EU legislator, therefore, just got there too late to amend the DMA to capture generative AI in some shape or form, as, for example, the final drafts of the AI Act did. Once it entered into force, the rules started to apply in May 2023, and the European Commission operated its first round of designation decisions in September 2023. And the substantive obligations in Articles 5, 6, and 7 started to apply for most gatekeepers in March 2024. As a response, actually, to these fundamental challenges posed by generative AI, MEPs, the European Parliament, the European Commission, and even the DMA's high-level group have proposed throughout this last year to try to address generative AI via the DMA, be that through, for example, adding a new CPS to the list of Article 2.2, or considering the implications of AI embedded within the currently designated services. Before these policy options, I considered on the paper two different aspects of the interplay between generative AI and the DMA. First, whether the risks posed by these systems may be identified with the broader problems of contestability and unfairness, and whether each layer of the AI stack may be regulated or merits to be regulated in the same manner. And second, I also question whether adding a new CPS would even be effective vis-a-vis the policy options that the European Commission may currently adopt. This last question I addressed by really setting out three aspects of generative AI and considering them under different lights. First, generative AI as an embedded functionality of the existing services of the gatekeepers. Second, generative AI as a technology. And third, generative AI as a standalone services. In terms of the risks posed by generative AI in general, I simplified the AI stack into three identifiable phases: pre-training, fine-tuning, and deployment. By identifying those stages to catering a generative AI service, I set out three main objects of regulatory capture, training data, AI inputs, and AI outputs. Pre-training entails developing the LLM's language capabilities until it successfully learns meaningful representations of language. Training data is used for that particular purpose, and the main risks and legal challenges precisely stem from this process, since high computing power and large unstructured data sets are needed to develop these language capabilities in the particular context of generative AI. Not many companies may access these resources with ease. In fact, there are also growing concerns surrounding the concentration levels on both the GPU and cloud computing markets, which cater to the computing power powering pre-training. On top of that, there is also a complete lack of transparency on what sources the training data extracts its information from. Examples of such opacity include the recent, for instance, New York Times suit against OpenAI, which also highlights the concerns around fairness posed by the training of these AI systems, since the value generated by different economic operators is not distributed equally across the AI stack. And finally, to the extent that the bottleneck of the access to data may touch upon the processing and collecting of personal data, concerns around the deployer's access to limited data also arise as a consequence. Once this LLM is pre-trained and has achieved those general learning capabilities, the deployer of the generative AI system must also make those general capabilities specific to particular tasks by incorporating structured data or AI inputs. As opposed to pre-training, the costs associated with these tasks are not so extreme. It is therefore not necessary for a deployer to start its AI system at the pre-training stage. That would make the AI stack only accessible to a few players. Most developers and deployers develop their models starting at the fine-tuning stage by building on the general capabilities of foundational models, opening competition to more economic agents at the downstream level. In parallel, however, the fine-tuning stage also purports some of the most consequential challenges of the AI stack, namely the black box problem. At this stage of the process, deployers start to provide the LLM with its specialized capabilities by generating these targeted responses and inferences for that particular purpose. However, due to the nature and the functioning of the underlying neural networks underlying the system, deployers have little control over the inferences generated by these specialized capabilities due to the whole complexity of the process. The very nature of self-learning AI operates with these unknown variables and sometimes autonomous inferences, which oppose the data protection principles of both transparency and purpose limitation. The lack of observability entails that the deployer has also a higher leveraging capacity than its competitors to try to extract value from those specialized capabilities. Moreover, the lack of transparency may also entail that the generative AI systems produce unwarranted results by the deployer. And once the LLM is pre-trained and fine-tuned, it will be rolled out and launched into real life and catered to the market. Deployment, however, is much more complex than that, insofar as the deployer must also put in place adequate safeguards to try to ensure privacy and security and to mitigate these biased results at the end user side. The nature of generative AI systems is inherently selective in this sense. A user inserts a prompt and the chatbot displays only one result from a range of alternative answers based on its likelihood. The selectivity of those results raises, therefore, just by itself, fairness concerns, since those results, when directed, for instance, at promoting a particular product, will not display the most targeted or the best answer, but rather the more likely successful answer or the most common answer. For instance, if we ask ChatGPT what search engine I should use, it will respond that Google search is the best service to use. By observing these different risks at the three levels, we can clearly see that they are quite different in nature, and thus they would require different instruments and solutions to be addressed. Bearing them in mind, I investigated further whether there is some potential for the DMA to try to capture those risks to the extent that they are not directly addressed, for instance, via the AI Act. And also I asked whether the regulatory capture would in the end result to be effective or not. To do that, I considered three different scenarios where generative AI could be incorporated under the regulatory scrutiny of the European Commission via the DMA. The first scenario consists of capturing the currently designated CPSs which have incorporated generative AI functionality as a feature. For instance, those include Amazon's integration of those tools on their marketplace, Google's new search engine experience, Meta's introduction of AI-generated content on Facebook and Instagram, or TikTok's incorporation of AI avatars as influencers as a functionality available for content creators on its social network. To the extent that those services would remain impacted, some of the provisions under the DMA would apply to them. A few examples of those impacts include, for instance, the application of Article 6.6 of the DMA. The mandate prohibits gatekeepers from introducing technical restrictions on the end user's ability to switch between services accessed using the same CPS. For instance, going back to the example of Meta's introduction of AI-generated content, the gatekeeper should not technically restrict competitor services such as OpenAI's DALL-E and Sora to create content on their social networks if consumers choose to do so. And alternatively, the data siloing obligations imposed both on personal and non-public data under Articles 5.2 and 6.2 would equally apply to these services. to the extent that they also process personal and non-public data to cater for those services in the market. Article 5.2 prohibits combinations of personal data across the gatekeepers' CPSs. This would mean, for instance, that Google's data used for pre-training or fine-tuning to tailor its search experience on its Google search CPS cannot be combined with personal data from its other CPSs, such as its advertising, shopping, YouTube, or map services. The most extreme, I would say, depiction and interpretation of the obligation would entail that each of these CPSs with underlying AI functionalities should silo its processing and combination of personal data at the LLM level, and they should therefore have different foundational models. But I believe that this would be too burdensome and unfeasible for deployers of AI systems, given also the high costs of processing and pre-training. On the side of Article 6.2, the provision compels gatekeepers to not use non-public data of its business users to compete with them at the CPS level. What would that mean in practice? All of the interactions with the functionalities on the gatekeepers' CPSs coming from their competitors involving non-public data should be directly siloed by the gatekeeper. However, this particular provision is also set at a crossroads with the functioning of generative AI in general, which also feeds on and improves with the interactions with humans and business users for its future interactions without the necessary intervention of the deployer. Additionally, if we take Google's new generative search experience, at face value, it really seems that Google's search CPS would be subject and impacted by the self-preferencing prohibition under Article 6.5 of the DMA. The prohibition would therefore entail that Google's displaying and ranking of a single answer at the top of the search page could be interpreted as performing the ranking function protected by the DMA. Thus, Google would be able to analyze and potentially discriminate or display differences between displaying that generated answer at the top of the page vis-a-vis the blue links ranked just beneath it. According to Article 6.5, the criteria of transparency, non-discrimination, and fairness would directly apply in the sense of the P2B regulation. That is to say, Google would have to disclose the main parameters it used for the ranking of that result and establish the reasons justifying the system's selective choice for performing ranking in that fashion as opposed to others. And here we would go back to this tension between the lack of transparency of these LLMs and the black box rationale that we pointed out earlier. And now, moving forward to the second scenario, I considered to capture this generative AI phenomenon via the DMA takes a completely different approach, i.e. considering generative AI as a technology. In this respect, since the principle of technological neutrality applies, the existing categories of CPSs can be used to capture generative AI services. As we pointed out earlier, one of the major problems in terms of the concentration in the AI stack lies in terms of the bottlenecks arising from the access to the computation power and data needed for pre-training. The clearest way to address those concerns, at least from the software side, would be to designate the existing or new gatekeepers regarding their cloud computing services, which are also included in the list of CPSs of Article 2.2. Alternatively, at the stage of their deployment, chatbots may also be assimilated into AI assistants. The list under Article 2.2 also contains virtual assistants as CPSs, so that services such as Apple's Siri or Amazon's Alexa, to the extent that they rely on generative AI, could remain captured by the regulation. However, the legal definition of virtual assistants under the DMA requires that those virtual assistants must interact with the physical world in performing tasks. The legislator, the EU legislator, when it added on this CPS to the list, was initially thinking about capturing virtual assistants impacting IoT devices. This possibility, therefore, does not seem to be quite promising. However, there is yet another CPS category which can be quite useful in this respect, and that is the one of search engines. In fact, OpenAI has recently launched its SearchGPT, and Anthropic has been developing and catering its Perplexity service for some time now. In line with the definition under the DMA, search engines intermediate queries formulated by the end users with search results, which are then indexed from the offerings of competitors at the downstream level. Although these generative AI reliant search services such as Perplexity display results in quite a different way, there is not much setting them apart from a traditional search engine like Google Search, since both intermediate with queries, prompts, and display end results by presenting, in the case of Perplexity, a result more prominently, but providing the end user with sufficient information to try to navigate the broader implications of the search result via links and additional links provided by Perplexity. In fact, in my own view, services such as SearchGPT or Perplexity trigger more of a problem, since the ranking and the selection of a more targeted result to the query bears a broader impact than traditional search engines do. From the DMA's perspective, their designation as search engines would trigger the application of two salient provisions, Articles 611 and 612. Those mandates would require them to provide access to click and query data to their competitors, as well as to make conditions for access fair, reasonable, and non-discriminatory. Both provisions would therefore have broad impacts on both the fine-tuning and the deployment stages of LLM's development, since transparency and the structured data inputted for fine-tuning may be required. And a related question to this arises relating to whether those LLMs, such as Perplexity, based on other foundational models, would fall under the scope of the application of the DMA, and whether the transformations required to meet the DMA's expectations would in the end fall within the remit of their own decision-making. And finally, this third scenario that would bring generative AI under the DMA's applications would be to simply act generative AI as a CPS category altogether. This policy option, of course, comes as a direct response to OpenAI's success and the problems that it has posed to both contestability and fairness once it has been deployed. In terms of procedure, however, adding a CPS category is not particularly easy for the enforcer or the legislator. The European Commission must first conduct a market investigation to determine whether enough concerns justifying the addition of a new CPS are given, and then it must draft an amendment to the regulation. That draft is then forwarded to the European Parliament and the Council, which have the last word in terms of reforming the DMA. The whole process would, in my own mind, take approximately 2 to 3 years to complete and to enter into force. And aside from that legislative process, the addition of a new CPS is deemed problematic in the context of the DMA, because some of the provisions underlying Articles 5, 6, and 7 only apply to particular CPS categories, such as app stores, operating systems, or search engines. Most of the relevant provisions I have highlighted earlier, such as Articles 611, 612, or the vertical interoperability mandate under Article 6.7, would not be directly applicable to them. For them to apply to a new CPS category, a separate amendment would be needed on the legislator side to reform those provisions and explicitly incorporate generative AI in the scope of their applications. And in substantive terms, there are also a few problems in trying to integrate generative AI as a standalone service under the DMA. Since the designation would be operated after the foundational models have been fine-tuned and deployed and scaled up, there would not be any direct impact on the pre-training phase as a consequence of the policy option. And because the DMA is basically not retrospective in its impact. And as such, altering the terms of pre-training seems to be too burdensome for any gatekeeper. And even if we stay within the fine-tuning and the deployment phases, there is also a fundamental tension with provisions like Article 5.2. The prohibition on the combinations of personal data across CPSs would apply to generative AI services vis-a-vis other services of the gatekeepers or third-party services. However, Article 5.2 has an exemption, and that exemption of the prohibition provides the gatekeeper may perform those tasks if it is granted with effective consent from its end users. However, the EDPB's ChatGPT task force has already declared that interpreting consent as a legal basis in this context is not quite feasible, since it is difficult to ask for consent from every single consumer impacted by the processing. Alternatively, Article 5.2 declares that the gatekeeper may in any case rely on alternative legal basis for processing under Article 6.1 of the GDPR. However, the DMA explicitly hinders the possibility of the gatekeeper of relying on the legitimate interest legal basis of the data controller. And according to data protection authorities, this is one of the few legal bases which could justify the AI deployer's processing of personal data in the context of LLMs. There is therefore a fundamental incompatibility with the DMA, its connection with the GDPR, and the application of the mandate under Article 5.2. And following with the problems arising at fine-tuning, similar problems as those outlined in a scenario 2 would arise with respect to the application of Article 6.5, since now the deployers of the AI would have to basically explain their functioning not only on their ranking, but on the workings of their black box functioning to the enforcer and potentially to its competitors, which also may be quite compromising for them and their business models. In conclusion, considering these three scenarios and three steps of the way, I believe that reforming the DMA is not the best policy option after all, since the specific risks posed by generative AI as a standalone service will surely fall amiss of the regulation. In scenarios 1 and 2, I explored that there are available tools for the enforcer to try to capture this phenomenon by interpreting the criteria, for instance, of transparency with respect to ranking or fairness or the fairness and non-discrimination principles in the context of the access conditions to the market. And with that, I have also included in the presentation a few of my latest papers, should you be interested in reading and touching upon, in reading my work touching upon the DMA. And I have also included the working paper version available on SSRN for you to read in depth. And of course, I am really looking forward to the discussion and to answering any questions you may have.